talking about Shaw v. Reno today, a court case a lot more recent than McCulloch, Maryland, by close to 200 years. A lot of time passed between them. So this is a lot more modern of an issue. Okay. So remember, this helps a lot when you guys help me. It goes faster, smoother, when you guys can provide some of these details for me from your case brief. You can read right from there. You can paraphrase your case brief, but I'd love to hear from you guys as to what you found for your case brief. All right, share what you learned from doing this case brief. All right, so let's start with case facts. Remember, this is what led, right? This is the issue that led to a court case, not what they ruled or anything like that. Like who's involved, what the problem is, all that good stuff, the background info. All right, so who can help with case facts?
I could do it.
All right, go ahead, Tahira.
So I said North Carolina's Attorney General, Janet Reno, had previously rejected a map created for House districting, which contained one majority-minority district, but approved one that contained two majority-minority districts, which upset the residents of North Carolina, led by Ruth Shaw. Shaw is challenging the constitutionality of these majority-minority districts in an effort to stop the North Carolina state government from attempting to put minority groups at a political disadvantage.
Good. Let's break down that that excellent case facts from Tahira. Couple of key terms. Make sure you understand from those case facts. Redistricting. Remember, this is what we talked about with the whole gerrymandering. It happens every 10 years. So when they redistricted in 1990 after the 1990 census in 1991, they created a majority-minority district. And what they mean by that is the majority of the people that live within this district, all right, were of minority ethnicity or race, right? So in this case, we're talking about Black Americans living in that district in North Carolina, right? So the majority of people living in that district were Black. Now, they submitted it one time, as Tahira said, because they had one district that was majority-minority. They rejected it, saying that North Carolina is so large, it has so many districts that they should have two majority-minority districts. All right. The reason why normally, let me back up for a minute. Normally, states don't have to get permission from the federal government to redraw district lines. However, during this time period, it was post Civil Rights Act and the Voting Rights Act. Remember, I guys told you that they were under pre-clearance. So anytime they change anything to do with elections in the states in the South have to get pre-clearance or approval from the Attorney General. So in the United States, they'll prevent them from making Jim Crow type of loophole laws. So this was, in essence, right, submitted to this lady right here, Janet Reno, who's the Attorney General, who said, no, one minority majority district is not enough. You need two. Right? And this is the goal here, the intent was to make up for the historical disenfranchisement of Black Americans in North Carolina and the South during that time. So to give them two districts that are all minority in nature, and therefore they're going to elect Black representatives to Congress. Right? It's seen as a positive thing to make up for all the negative treatment of Black Americans in the South during Jim Crow era and before. So that was the goal. However, Shaw, representing the state of North Carolina, or citizens in North Carolina, are going to challenge this and say that this is unconstitutional and does not provide equality in voting. Okay? So it's unequal in terms of voting. And what part of the Constitution are they going to cite as the constitutional provision? Who wants to help me with that?
The 14th and the 15th Amendment.
Good. It's one of them, right? It's just the 14th Amendment that we're talking about here. All right. And because the 15th Amendment just more or less says that you can't deny people the vote based on things like race. However, we weren't denying in this case, right? They were not being denied the ability to vote. They were denied, though, the equal protection or equal or equality of voting among the districts. For that reason, it's the 14th Amendment Equal Protection Clause. Right, there are two main clauses I've talked about with the 14th Amendment. This one is dealing with the Equal Protection Clause, saying that states cannot deny someone the equal protection of the laws, regardless of race, ethnicity, gender, age, any kind of demographic factor, basically. Religion, anything like that. So everybody's equal under the eyes of the law under the 14th Amendment. And states cannot create a law, in this case, a district that infringed on this. So that was their case, right? So Shaw, leader of Citizens of North Carolina, saying that people within these districts were having their equal rights, right, or equal protection under the law infringed on. So this district is unconstitutional according to them. Right, so what is the legal question then at hand? What was the basis for the case, right? What was the broad question they're trying to answer?
I said, can states create political districts dependent solely on race?
Great job, Tahira. Yes, that is a great one. Can you say that one more time? Because it was just that great. Sorry, Tahira, could you repeat that legal question that you had one more time for everybody?
Yeah. Can states create political districts solely dependent on race?
Yes. Can those states create political districts, in this case, congressional districts, that are based solely on race? Right? Because if you remember from the case brief that you read, they talked about how bad these things were gerrymandered. And you can see that in the picture here. They said at some points the area was no wider than the interstate, right, that they drew. And if you held both car doors open at the same time while you're driving, you'd kill the majority of people in the district. Right? It's that small is what they're saying. Right? And they even talked about how they had to be very creative in how they drew it. And that's why it looks so weird, because they had to draw in such a way that basically gobbled up, as they said, all of the Black community enclaves, right? Little areas or pockets of Black communities that existed in these areas. And so they had to exclude all the white communities and only include Black communities to get the second majority district. And so it was clear, right, that they drew these lines solely for the basis of race, which is what basically Janet Reno told them to do. The states, they told the state of North Carolina, you need to draw another district that gives minorities a whole nother district that's a majority. So now the question is whether or not this is constitutional, right? Can you draw these districts solely based on race? No other factor, right? No reasonable person can look at this and say, oh yeah, they drew it for other factors involved, right? This was solely based on race. So the question now becomes, is that constitutional, or does it violate the 14th Amendment Equal Protection Clause? Okay. So what was the holding, right? Remember, this is the direct answer to that legal question of, can you draw districts based solely on race? What did the court rule here?
I could just read what I put again.
That's good. Go ahead.
So I said gerrymandering cannot be dependent on race, therefore there cannot be majority-minority political districts.
Great job. Yes. So yeah, they cannot do it. States cannot redraw their congressional district lines to gerrymander on the basis of solely race. Right? Make sure that term solely is in there, right? Or only, or any type of similar term. We're going to get to that in a minute. All right, so what was their reasoning here? So why did they rule that this was violating the Equal Protection Clause? Somebody on my side's to Hare. She's got the team on the back today. Let's
Okay, I'll go.
all right, go ahead, Leslie. Thank you.
I said the purposeful segregation of voters in different districts contradicts the goal of a colorblind electoral process. And by the Equal Protection Clause, we must prevent states from discriminating between individuals based on race, and to have a particular race fall majority in a district to maintain compactness and territory, there may be a justified reasoning. However, to create such an irregular blueprint that concentrates on one race, the motivation stands clear behind it in a district that obviously targets a particular race with common interests, solely represents that group rather than the whole, and that opposes us as representative democracy.
Good. All right, so some of the key points I'm taking from your argument there is that number one, that this sets a dangerous precedent that if we allow this gerrymandering based on race, it can lead to abuses in the future. If we say that this is okay, we could see states draw the lines for the opposite intent to basically make sure that white Americans have a majority district in their state. So if you allow this to happen, right, it's a dangerous precedent. It's unequal in terms of our democracy because it's supposed to be based on the representative will of the people, right? Not the representative will of a particular race, right? But people referring to all people, not just a particular race. And so that goes against the democratic ideals of our government. The whole purpose is to get the whole view of the government, of the people in government. And so what they basically said was that these lines that you see that are drawn there are arbitrary in nature, and sole purpose is to divide people that have no real commonality on the basis of race. So these people over here in this part of North Carolina and these people over here in this part of North Carolina really don't have much in common except for they're part of the same race. And that's not really the intent, right? It's just to group people in different areas geographically, because in that area you're more likely to be representative of the same type of values. Right? Each part of the state is represented, not each race is represented, is the goal. Okay? And so by doing this type of map, they are violating the equal protection rights of all the citizens in North Carolina, despite the good intentions of trying to right a historical wrong. Right, the intention was to make sure that blacks in North Carolina were able to receive equal representation. Right, 2 districts of representation that's almost guaranteed. But by guaranteeing representation to a particular race, you've actually violated the Equal Protection Clause as a result. And if you were to, the Supreme Court were to say, like, yeah, this is okay, like I said, this sets a dangerous precedent by saying, okay, well, if they can do it for black citizens in North Carolina, why can't they do it for white citizens in Alabama or some other state, right? So they had to rule this way for many different reasons, but the precedent sets is dangerous if they were to rule the opposite way. All right. I also like the part where this is Justice Sandra O'Connor who wrote this opinion. She does a good job of giving this analogy. It talks about basically this is too similar to political apartheid. If you're not familiar with apartheid, it was in South Africa where whites and blacks were segregated in South Africa. Blacks were unable to vote in a significant manner, and therefore never had any type of representation until after apartheid ended, and that's when Nelson Mandela takes over. Right, he's able to actually win an election, and so if they were to rule this way, right, and in favor of allowing this, they could basically enable apartheid to happen in the United States. It's too similar, is what she said, and so it's a dangerous precedent. She also says that this reinforces the stereotype that all people of the same race vote and think alike, which is another dangerous stereotype and dangerous precedent set, and that we shouldn't vote as and be represented as a people based on our race, but rather as equal competitive race that reflects the values of a particular part of the state. It's also, again, I keep using this term dangerous precedent, but imagine the precedent it would set for elective officials in that district. All right, so if you're in District 1 and District 12, and you are obviously going to be a Black representative representing mostly Black North Carolina citizens in your area, you would have the implication, right? It would be implied that you are expected to represent a specific race in Congress. We don't necessarily want people to represent a specific race or even like a religion or any type of demographic only. Right? We want our people in Congress to represent all Americans equally and care for both majority and minority values within their district. But if there's only one particular race in a district, they only have to account for one particular race's point of view. And again, imagine that in some other fashion across the United States where I give the example, what if they made a majority of districts in Alabama are all white? And therefore the representatives are only going to promote white American values, right? So that's not something that we want to be the precedent that we set, and therefore gerrymandering based on race alone is unconstitutional. Now, they did concede and say that race can be a factor, and this is the key, race can be a factor, but it cannot be the sole factor or the only factor. We cannot have a completely colorblind society, right? You have to take into consideration all demographics when drawing these lines. The same way that you'd have to take into consideration any other state law that dealt with race. So if you're dealing with a race, if you're making a law that deals with race and whether or not somebody receives a benefit or part of government as a result, it needs to be a very good reason, a compelling reason is what they say. And it must be very narrowly tailored, as in it's very specific to that particular topic that they're trying to fix or the issue they're trying to fix. And so redistricting is no different. You need to make sure that this district is set up in such a way that it helps promote equality, not discriminate or cause inequality as a result. And so again, the whole crux of this case is that while good in intent, right, you cannot make these majority-minority districts because it sets a dangerous precedent that if we allow redistricting based on race, that it can lead to abuses in the future. And it also sets a dangerous precedent that the representatives of those districts would only represent a particular race in Congress, not all people within their area, right? Or all those people within their area are of one race, and therefore they would just be able to ignore other races or other types of viewpoints as a result. We don't want that. We want all viewpoints and all races to be considered in our government, and therefore it violates the Equal Protection Clause. So the end result, gerrymandering based on race is illegal, unconstitutional. It can be a factor when considering and redrawing these lines, but it cannot be the only factor.